proceed.
Thank you, Mr. President, and good morning to everyone again, and good morning especially to you, Dr. Campbell. Let me pick up where Judge Cartwright left off, because apparently you were shown the one-page letter that was dated November 7th. We received it this morning in light of the time difference, and you dismissed it as being little or no value. That was what you said, that it has little or no value. That was his assessment of your medical report. Now, picking up from that, I take it that you might change your opinion if, for instance, this particular doctor were to have access to the entire file as you did. The medical records, your previous reports by other doctors. Perhaps you might be willing to review your position. Would you not?
Objection, Your Honour.
The President, International Prosecutor, you may proceed.
My apologies, I don't really want to interject on Learned Counsel's first question, but I would submit that this question is objectionable because it relates to speculation. The question assumes that if this expert received the documentation and had access to the same material that this professor has, he would have the same opinion. And I think that's the point that Judge Cartwright made, was that if that material was made available, perhaps his opinion would be more informed and different. So I would ask that that question be rephrased, or a different approach, because it is based on speculation that the opinion would be exactly the same when he's better informed, when clearly that may not be the case.
I welcome the objection because that's my point. Would you have any objections, Doctor, to having this particular doctor review all of the material that you reviewed, to review your reports, and to provide the trial chamber with an opinion?
Objection, Your Honour.
The President, you may proceed, Mr. Co-Prosecutor.
Again, I apologise again, but I think the question is probably not really appropriate for this witness to say whether or not it's okay for another expert to review the material. That's really a question for Your Honours, and it's not really up to the witness to say that's appropriate or not appropriate.
Doctor, were this particular doctor, who Judge Cartwright indicated that he is a supposed forensic psychiatrist, and we're going to get to that, if he were to review all of the material that you reviewed and your reports, would he be in a better position to give a more informed opinion and assessment about your particular report?
The President, lead co-lawyer for the civil parties, you may proceed.
Good morning, Mr. President, and good morning to all. I do have the feel that this question is absolutely identical to the first one asked by my colleague from the Ieng Sary defence. Not only repetitious, it is also inappropriate.
If I may respond. The thrust of Judge Cartwright's question was that this letter here is meaningless because the gentleman, the doctor, the professor who reviewed it, only looked at one report and one report only. Of course, we weren't at liberty to give the entire file. And based on that, Dr. Campbell indicated that he saw little or no value in this assessment because obviously our expert that we consulted, pro bono, on a last-minute basis, had very little to review. Now, I'm asking this doctor as an expert. Were another expert to have all of the material that you reviewed, would that expert be in a better position to provide an assessment than the one that was provided overnight? It's a yes or no. I'm sure the doctor can answer the question. He may disagree with the assessment, but he certainly can answer my question.
Well, I would consider it totally unnecessary.
Look, the President, Professor Campbell, could you please hold on? Counsel for this, Mr. Ieng Sary, Mr. Canavas, please rephrase your question and try your best not to allow Professor Campbell speculate when responding to your question. Rephrase your question, please. And the chamber has already reminded the parties that the documents issued by the chamber are allowed to be submitted to people concerned, but then we have been informed that some of the documents should not be placed in these proceedings. However, please be reminded that the question is rephrased and try to avoid any question that is speculative.
Thank you, Mr. President. Now, Doctor, I care not to hear your opinion as to whether you think it's relative or not relative or necessary or not necessary. What I want to know is, because you dismissed this letter, were this particular expert to have access to your previous report, the other reports by the other doctors, the entire medical history, would such an expert be in a better position to provide perhaps a more informed assessment based on your medical experience now? Now, if you're unable to, I don't want you to speculate.
Again, Your Honours, I apologise, but I think just in relation to the question, so that the court record is accurate, I believe the transcript doesn't say that Professor Campbell has dismissed the letter outright. Particular propositions were put to Professor Campbell, and he responded on those propositions, and for one or two of them, he dismissed them. But to say that Professor Campbell has dismissed the letter outright, I don't think is an accurate account of today's proceedings, and I think it's a little bit misleading to the professor.
Mr. President, I understand the need to obstruct. I'm perfectly willing to go through the letter and see what parts of the letter Dr. Campbell would accept, such as where he's criticized for applying unacceptable methodology. Do you agree with what this doctor has said about your report? He indicated to Judge Cartwright's question that he saw little or no value. That was a quote, little or no value. So my question now is, if this particular doctor, this expert, this professor, were to have access of your previous reports, the previous medical records, would this doctor be in a better position to give a more informed assessment of your current evaluation?
Mr. President, Council Kanawaz, the Chamber has received your request concerning the submission of the sending of documents with regard to the reports compiled by Dr. Campbell. And according to your request, the document concerning the consultant opinion would not be put into the case or into this today's session. But now we know that the document is being debated, and also we know that the questions posed to the experts were in the form of speculative natures, using the terms like if or were, it like that. So it is the discussion of the trial chamber to make a decision concerning this matter. It is not the expert. In light of this, the chamber wishes or does not allow Dr. or Professor Campbell to respond to such question. You may rephrase.
Thank you, Mr. President. Let me just address one point. First of all, the door was opened by Judge Cartwright. I apologize, but she did open the door by making reference to it. And the email that we received yesterday from Chambers was that Chambers does not envisage. Now, envisage, at least how Americans understand that word, means that not expected. We were not forbidden to get something such as this. Nor was there a prohibition about trying to get an assessment and even provide the assessment. Secondly, obviously not only Judge Cartwright opened the door by going directly into the substance of the letter, but it would appear that the doctor saw the letter himself, because otherwise how could he be so cavalier in saying he has little or no value? He obviously answered that question based on what he saw. And it was an informed, I suspect it was an informed opinion. Doctor, you will get a chance to respond. Now, I don't see how the trial chamber can go into a particular document, ask questions, elicit answers from the doctor, who then says it has little or no value because you only looked at one report and not the entire medical history. And then when defense asks this very same doctor whether a more informed opinion could emerge from an expert if they had the entire file, which is not speculative, because obviously he's here as an expert. I don't see how that's objectionable. But I'll move on. I take it that we are not allowed to confront the doctor on this issue. However, because Judge Cartwright impugned in some ways the reputation of this doctor by saying supposedly, I would like to present to this witness document E115.2.2, which is the resume of Dr. Harold J. Bernstadt. It is a 29-page curriculum vitae. He's from Harvard University. It has all his qualifications, and there's nothing supposed about this individual being a qualified expert in the field in which he's representing himself to be. And I think by using the word supposed, it does give the impression, regrettably, that this guy may be a hoax. And I'm sure this gentleman, if he looks at the CV, he can at least tell us whether he's recognized or heard of the institution called Harvard University Medical School.
Your Honor.
The President, International Co-Prosecutors, you may now proceed.
The first point, Your Honor, I object to the counsel's characterising of the witness's evidence as cavalier. I don't think it's appropriate that counsel puts these types of terms on a witness who's giving factual evidence. He's giving his opinion. There was nothing cavalier about his opinion this morning, and I think it's quite disrespectful to speak about witnesses in that manner unless there is a reasonable basis to do so. Secondly, Your Honour, the defence have exactly contravened the rule that you put in place through your legal officer yesterday. It's quite clear from the email that as an exceptional measure, which I thought was quite appropriate to allow the parties at least to consult a medical expert to at least understand the reports. I thought that was an appropriate request. But it was very clear from this chamber, through your senior legal officer, that it was such an approach was just to use to assist in the understanding of those reports. Now, what counsel is trying to do is they're trying to introduce evidence into the court which is not subject to the admissibility rules of this court, Rule 87.4, not put it through those procedures, and then at the same time ask specific questions, detailed questions, asking to show the CV in the courtroom when no application has been made under 87.4. And as Your Honours are aware, your ruling in this court that where particular documents are to be put to an accused, Rule 87.4, an accused or a witness, Rule 87.4 applications must be made. And certainly we would be objecting to that application this morning, certainly on the same basis as the defence have said that their time to prepare for this hearing this morning was too short. And obviously it follows the time for the expert that they consulted to prepare for today was clearly too short. And so that's why we'd be objecting to that letter and the CV being placed on the case file, because he hasn't been given a proper opportunity to provide a reliable opinion. So I would ask that the showing of CVs, the showing of documents, and the putting specific questions based on the document cease, and the ruling be followed, that the understanding of that ruling being that parties could seek consultants to help them put proper questions to the witnesses that relate to his findings in the report.
If I may briefly respond, Mr. President, perhaps the word cavalier was too strong, and I withdraw that. What I meant actually to say that perhaps it was the professor's view that this report here, this letter, this assessment was more or less cavalier in the sense that it was very short in nature and not based on having been reviewed the entire medical history. So to that extent, I offer my apologies to the doctor if I had offended him. But with respect to the rest of the objection, and here's where my learned colleague is absolutely 100% wrong. I did not come into court today prepared to use this letter, although I had it with me. I circulated it as a matter of transparency. I thought it was my obligation to do so. Judge Cartwright introduced it, or in a sense, made reference to it. I was not prepared to share with this doctor the CV, who I'm sure he knows the CV from a previous hearing. But once the word supposed came into play, then I felt compelled to have an extra copy brought and to have my copy available, because I thought this would be necessary. So I'm only reacting to what is happening in court. Now, I apologize for being prepared for the eventuality that something like this may happen. But I certainly did not ask that the letter be introduced. I could have done so early this morning when we circulated the email. I thought I was being forthright. I thought I was being conscientious. I thought I was doing my job. Because I certainly could have, if I wanted to, tried to spring it on the doctor from here and claim somehow that I didn't know what the procedure was. Now, I'm perfectly willing to move on. But I don't wish the record to reflect that somehow we intentionally go out of our way to violate these rules. I react based on what is happening in the courtroom. And so I'm willing to move on, but I do think that the record should reflect that we have acted properly throughout these proceedings. Thank you.
The President, the Chamber would like to hand over to Judge Cartwright to address this issue. Judge Cartwright, you may now proceed.
Thank you, President. The prosecutor was correct in his summary of the purpose which the trial chamber had in mind in allowing counsel to consult appropriately qualified medical personnel to enable them to prepare for the hearing today and to make sure that any technical aspects of Professor Campbell's report were clearly understood by the parties. The difficulty with this particular letter is that it has been filed by the Ieng Sary team, and I certainly accept that that was for purposes of utmost transparency. It cannot, however, be treated as an expert opinion for all the obvious reasons, and I see Mr. Carnavas agrees with that. What Mr. Carnavas can do, and it's entirely appropriate for him to do, is to put to the expert information from that letter to enable the court to understand fully Professor Campbell's expert opinion. And that is the basis on which the questions were put earlier today. Now, no one's reputation is being impugned. The fact of the matter is we are unable to make any determination as to whether this consultant is in fact an expert. It's as simple as that. So, Mr. Carnavas, you are quite at liberty to put propositions to the expert, and in case it's not been made abundantly clear, because the letter came in and was filed this morning, Professor Campbell was given a copy of it. So it's all out there in the open. It simply cannot be treated as an expert opinion. Is that sufficient for your purposes, Mr. Carnavas?
It is, and we were never submitting it as an expert report or an expert assessment. Nor did I think that it would generate this much controversy. Let's set that aside for a while and see if we can move on to something more pleasant, and then we'll return to that. Dr. Campbell, I've noticed that throughout this morning, when questions are being posed to you, you're looking at the judges or the lawyers, you're having to hear the questions, process the information, and then you provide informed answers. Would you agree with me that a certain amount of concentration is required for you to do that?
Yes, of course.
And I take it when the questions are coming, say, from the Cambodian judges through a different language, you have to pause, wait, listen very carefully, and sometimes maybe even adjust your thinking depending on the quality of the translation, so that the interpretation, so you understand fully the thrust of the question being asked. Would that be correct?
That is correct. It's the same process I go through when I talk with Ieng Sary, because I have to go through an interpreter, and then his answers are given back to me through the interpreter.
Right. Now, would you say, and here's where you might be able to help me out a little bit, is it the same level of concentration that one would need as the one we just discussed with, say, participating in, following the proceedings? Or would you say less or more is required?
No, the concentration is the same, whether listening to the proceedings or whether I am interviewing Ieng Sary. In fact, having the interpreter makes it easier because it gives additional time while it goes through the interpreter. So it does not have a significant effect on the concentration.
All right, well, maybe I was inarticulate in the way I phrased my question. I guess what I'm trying to decide, to figure out here is, would an individual require the same level of concentration as you require in listening and answering questions to, say, sitting in court or in the holding cell and following the proceedings? Are we talking about the same quality of concentration required over a sustained period of time from 9 o'clock to 4, in between with the breaks? So are we talking about the same quality, in your opinion?
Yes, we're talking about the same quality of concentration, be it in the court or when I am interviewing Ieng Sary as a clinician.
All right. I'm just going through the general. We're going to get to Ieng Sary, but I'm just going through the general. I just want to make sure that what you're saying is when you are determining whether Ieng Sary or another accused is fully capable of following the proceedings, concentrating for the entire day, assisting their lawyers, we're talking about the same level of concentration, whether it's you as the witness or him as the accused.
Yes, I presume so.
Okay. Now, with that in mind, prior to the proceedings, I visited my client. He was in bed downstairs with the oxygen, and he's on his side, and he's barely coherent. Now, would you say that that is the same, someone in that condition is fully capable of concentrating to the level you've just described is necessary for one to assist in his own defense? What do you think?
President, Dr. Campbell, could you please hold on, and co-prosecutor, you may now proceed.
Your Honour, I have no objection. Of course, the line of questioning is appropriate, but counsel was giving evidence from the bar table as to his assessment of the mental and physical condition of his client this morning, and that's not appropriate to put that question. He can rephrase the question to put perhaps different situations, but to make a premise of the question a fact that's not proved or not really before the court, apart from the counsel's own observations, that's not appropriate. And so I would ask that if he changes the question in a different way, then it will be less objectionable, because it places on record something that is not evidence.
I have no problems rephrasing. Doctor, before coming here today, did you happen to see Mr. Ieng Sary, to visit him in his holding cell to see in what condition he was in?
I've not seen Ieng Sary today. As I've said, I've seen him in his hospital. I've seen him in his holding cells, in the holding cell and in his detention centre previously. And always on those occasions, he has been fully able to concentrate and to respond. I imagine if he has been seen just after moving to the holding cell, for example, he may well be more breathless for a time, but once that settles, I see no reason why he shouldn't be able to concentrate and respond.
Of course, now you're speculating, aren't you, Doctor? Because you haven't seen him, you haven't witnessed him, you're not there for the entire day. So are you not speculating somewhat that he's able to concentrate for the entire time? Thank you.
I'm giving an opinion based on my examination of him and the time I have spent with him.
All right. Now, and we're going to get to your examination, but I just have one more question, and this will be general and it will fit within the parameters set by the prosecutor. If an accused is in his holding cell and is dozing in and out while the proceedings are going, is feeling dizzy, or is even asleep, in your medical opinion, is that person cognizant enough to be assisting in his or her own defense?
Well, on my examination of Ieng Sary, I have no evidence that he would be asleep or dozing off during his period in the holding cell. I'm not sure of any evidence that that actually occurs.
Doctor, I understand the need for you to constantly talk about Ieng Sary. I'm asking you a general question. We're going to get to your examination. So if you could kindly answer my question, and if you don't understand my question, please tell me. Now, can you answer my question? Would you consider that person to be assisting in his own defense, concentrating, being able to process the information, then being able to give instructions to their counsel?
Your Honour,
The President, you may proceed. Co-prosecutor and Dr. Campbell, could you please hold on?
I object on the basis that it's a vague question. It's one in which he talks. The factual basis is that this factual situation is that the person's dozing, they're asleep, he's putting a lot of factual propositions which are really quite vague unless he's more specific to the professor, so he can give a reasoned opinion. We've got no objections to asking the professor's expert opinion on if my client was asleep, is he following the proceedings? Clearly, he's not. But counsel is asking for a very specific legal opinion to an extremely vague factual situation. So if that was refined more, then it would perhaps give the professor more of an opportunity to give a valued opinion rather than sort of a general discussion. If my client's asleep, is he following the proceedings? Of course, the answer is obviously not. He's asleep. So, but perhaps if he's more specific, it would be more helpful to Your Honours.
Mr. President, I understand the problem that the prosecution has, and I can understand their strategy and tactics. But generally, the way I've been trained and the way it's normally done, you can go from the general to the specific. The way the question was asked is rather simple. There's nothing vague about it. There's nothing complex about it. And we have this doctor, who's a professor, who's here before, he's testifying, we're speaking the same language. Clearly the doctor is capable of answering that question without going into any specifics. Now, we will go to the specifics. So, can he answer the question, or does he find it vague? I would leave it up to the doctor.
Well, there are two issues here. Is the person capable of concentrating, and are they concentrating at the time? Now, I've dozed through a good few lectures. It doesn't mean I'm not capable of concentrating on them. And so, for my examination of Ieng Sary, I've not found any evidence that he is not capable of concentrating. That doesn't mean that he may not doze off at times. As I've said, many of us do, if there's not much that's actually maintaining our interest at the time.
So, in your opinion,
The President, Counsel Kanawaz, please observe some pauses, because without doing so, your message is not properly rendered through the interpreting channel. So please be less abusive in this.
Thank you, Mr. President. Sometimes my exuberance takes the better of me. Now, so I take it, based on your answer, dozing off is just a natural process, and therefore, if someone like Mr. Ieng Sary is dozing in and out for the proceedings, he's nonetheless following them, in your opinion. Is that what you're telling us? Or did I get it wrong?
You got it wrong. What I'm saying is he's capable of concentrating.
Right. Okay. Now we'll get back to that perhaps later, but let's go to your examination. Now, I realize that you have met with him before, and so you were familiar with his medical history. And we note that you were provided with a series of documents in preparation for your examination. May I ask whether you reviewed all of those documents prior to meeting with Ieng Sary?
Yes, I did. I reviewed all the documents dating from the time when I had last seen him, and I'd reviewed all previous documents and my previous assessment.
Now, I'll pause. Now, it would appear that you were also provided with the transcripts of the testimony from the previous hearing, unless I'm incorrect. And, of course, letters, correspondence that the Ieng Sary defense team had with the trial chamber concerning Mr. Ieng Sary's health care.
Yes, that is correct. I've read the transcript. Some of the statements in the transcripts attributed to the doctors are very difficult to understand. I'm not sure if that is due to problems with the translation. Some of the conclusions they draw are clearly not correct.
All right. And so, well, in one of our letters where we make reference to the to the transcript, and this is the letter of the 24th of October, 2012, we noted that on the transcript page, Dr. Lim Sivuta indicated that more than 15 minutes, they were unable to really carry on, interview Mr. Ieng Sary. The maximum period was about 15 minutes. That wasn't the case that you found when you met Mr. Ieng Sary.
No, not at all. I saw him for an hour to an hour and a half, and there were no problems during that time. What page of the transcript is that?
It's on page 62 to 63. Now, obviously, from your testimony today and from your report, you disagree with the Khmer doctor's assessment, medical assessment. Is that correct? Well, if you were provided the transcript and you were provided the letter, Doctor, and you indicated that you reviewed all this material prior to that. Surely, if we had misstated the facts, you would have caught that.
The President, Co-Prosecutor, you may now proceed.
Your Honor, no objection, but I'm just wondering whether the passage from the letter could be read to the expert so he understands the basis of the question and answer more concretely. Because the passage is not so general in a sense that was put forward by counsel. They refer to one interview had to be limited, and then after that they state that I think so far the maximum time we spent interviewing him was about 15 minutes, but the limiting of the interview related to one incident. So it's not quite clear whether all interviews could only extend for 15 minutes because of the limitations, or it was just that one interview that was limited and the other interviews just happened to be for 15 minutes. So perhaps if that passage could be put, at least the doctor would be able to answer more clearly.
Again, Mr. President, the purpose of submitting this letter, which obviously the letter was to provide information to Dr. Campbell, was to highlight areas that we saw concerned with the testimony by Dr. Lim Sivuta. Now, on page 2, over a 3-page letter, under section 4C, we point out exactly what was said. Now, let me read the passage of the letter, because I don't want to spend the entire day going through the transcript, although I'm perfectly willing to do that. So if you get the letter out of 24 October 2012, and if you don't have a copy, one can be provided for you. Okay. Or I'm told it's on the screen. It says, Dr. Lim Sivuta statement concerning Mr. Ieng Sary's concentration, quote, "To me, I do not see any concern regarding this aspect. But of course, I'm not the expert in this area." Transcript page 32. And, quote, "I don't think that there was any issue in relation to his concentration." Transcript page 52. Even though Dr. Lim Sivuta recognized that, quote, Mr. Ieng Sary had fatigue once he had to respond to a question. So fatigue was the main problem facing him. And if we raised our voice, for example, then he attempted to respond in a louder voice as well. Then he was rather exhausted. So we had to limit the time for the interview. I think so far the maximum time we spent interviewing him was about 15 minutes. Transcript page 62 to 63. Now, keeping these passages in mind, let me ask you this question, Dr. Campbell. Assuming that Dr. Lim Simvuta is correct, assuming that he's telling us exactly what he was able to observe, so we have to accept him at his word, would you say that someone in this condition, where they're fatigued after approximately 15 minutes, are they capable of following the proceedings and concentrating to the level necessary to assist in their own defense? And I'm not asking you to tell me what you observed when you met Ms. Ieng Sary. I'm just asking you based on this. We're going to get this step by step.
The transcript, page 62, indicates that the interviews would normally take 10 to 15 minutes, and that would be the normal time for someone reviewing a person's condition. There's no indication in the transcript that it was fatigue limiting that. That was just the normal time, as I've said, that one would interview someone when one is doing a routine review.
All right, so you disagree with what he's saying over here, with the part that I quoted. Had fatigued once he had to respond to a question. So fatigue was the main problem facing him. You're saying that's not in the transcript, or that's not what he observed. Which of the two? I take it neither.
That certainly, as I've said, not my experience with him.
Well, I'm not asking you for your experience, and that's what I'm trying to get at. We're going to talk about your experience. I'm asking you, based on what this doctor saw, based on his description, would you say, based on your definition of being able to concentrate, someone who is so fatigued, based on the description given by the doctor, would this person be able to concentrate for an entire session?
Your Honour, I would object to the question, because as the Professor said, I think counsel is mischaracterising the transcript. What the doctor states is that on one occasion he was fatigued and he got quite exhausted. So we had to limit the time for the interview, not all the interviews, for the interview. And then the doctor goes on and says, I think so far the maximum time we spent interviewing him was for about 15 minutes. And as the Professor has said, the interpretation of this transcript, the interpretation is not that all those other interviews only lasted 15 minutes because of the fatigue. It just so happens that the doctor has said, look, the interviews were for 15 minutes, all of them. But there was one occasion where they specifically state that he was fatigued and exhausted. So to characterise that all of the interviews could have only proceeded for 15 minutes misrepresents the transcript.
Mr. President, again, this is a clever way of obstructing, because he's mischaracterizing the thrust of my question. I'm trying to draw out the doctor to see whether, based on the testimony that we have from that we have in the record so far, whether based on those conditions as described, someone would meet the level of concentration, as he's told us earlier when I asked him what is the level of concentration needed to assist in one's defense. If someone is so fatigued that after 10 or 15 minutes can no longer answer questions, is that person capable? Now, I understand the doctor did not see that. I'm just going from the general, and then we're going to get to the specifics. So, can he answer that question? And no replies are normally allowed, Mr. President. That's...
The President, co-prosecutor, you may now proceed.
Thank you. I don't think it's the first time that counsel has had tried to attempt a reply. In any event, Your Honours, what counsel is doing, he's mixing questions of fact and speculation. If he wants to put a hypothetical situation to the doctor, we have no objections, if it's specific enough and not vague. But what he can't do is speculate and mix fact with that, and mix fact incorrectly. He either has to do one or the other, put the exact factual situation which we say was a misinterpretation of how he put it, or he puts a hypothetical situation. But once he starts to mix hypothetical with fact, then the answer becomes virtually worthless because it's not based on any solid grounds. That's all we ask. The two techniques are fine, but we just would ask that he doesn't mix them in the same sentence.
Well, Mr. President, that's why I gave him the transcript. That's why we...
The President, the objection is sustained. Mr. Expert is directed not to respond to that question.
Take it, Doctor, that you did not spend an entire day with Mr. Ieng Sary, say from 9 o'clock to 10:30, take a 20-minute break, go until 12, take another 1 hour and a half break, then go until about 3:30, 3:40, take another short break, and then go until 4 o'clock. You did not do that on any of your examinations, did you?
No, I did not. I saw him for an hour to an hour and a half. He was showing no fatigue at the end of that session. He then had a break, and he was fully alert when we came back.
Thank you. Now, so the answer is that you never conducted a test replicating the actual times that he would be sitting in court to see whether, say, at 3 o'clock or at 3:30, he would be alert and able to concentrate, to follow the proceedings, not dozing in and out, not falling asleep. You did not conduct or try to replicate the actual hours of the court.
No, that was not done either by me or by the Dr. Sina Fazell, for example, when he saw him previously, because we saw no need for that. He had concentrated fully. There is no evidence of cognitive impairment when we've assessed him.
All right. So based.
The President, Counsel, we know you understand my gesture. You went too fast. You may proceed, but slower, please. Because when the red light is still on, when Professor Campbell still had the floor, then you proceeded, it would bring a lot of difficulty to the rendition.
All right. Now, so I take it, Dr. Campbell, that it is your medical opinion that if you test somebody in the morning, as you did, hour and a half, and then have a little break, and then you determine that that person is able to concentrate, based on that test, you can conclude to a medical degree of certainty that in the afternoon, that same person, given the constraints that they may have, physical and mental, would have the same capacity to concentrate as they did in the morning session when you met them.
The President, Professor Campbell, please hold on, and International Co-Prosecutor, you may now proceed.
Again, the question is mixing fact and a hypothetical. For this to be useful, I think it should be put that given that he mentioned that look, given the situation for a person that has physical and mental constraints, the professor has been testifying all morning that Mr. Ieng Sary has got no mental constraints. It would be different if he said, assuming someone has a health condition, some health problems like Mr. Ieng Sary, but still of having the full mental facilities, which is his evidence, would he get tired in the afternoon? But what he's premising the question on is that this person has physical and mental constraints, and then would he get tired in the afternoon? And that's certainly not the professor's evidence, particularly if they're trying to use an example that will assist the court. That's misleading the witness that the Ieng Sary has got mental constraints as the basis of the question.
I'll rephrase, Mr. President. Let me be specific. All right? It is your medical opinion that since you've tested him in the morning, hour and a half, break, then again you saw him, given his state, physical, mental, whatever it may be, we're talking about the same person, so there should be no confusion from the prosecution. So it is your medical opinion that because you tested in the morning, obviously it must follow, as day follows night, that in the afternoon he would have the same alertness, the same abilities to concentrate. That is your medical opinion.
Yes, both I and the others who saw him earlier consider that he would be able to concentrate. Clearly, people's ability to concentrate does vary during the day. We're more likely to have a snooze after lunch, for example, but that doesn't mean the person's not capable of concentrating.
And in your examination, of course, this time, you did examine him in the afternoon to see whether, in fact, this was the case with this particular individual, Mr. Ieng Sary, in light of the conditions that he was in.
Now, we examined him in the afternoon because by the time we'd finished in the morning, it was the natural lunch break, and so we saw him after lunch. And that time, again, went through memory testing, which he performed well in.
All right. So, give us the exact hours. When did you test him? In the morning, and then when in the afternoon?
I think we must have tested him in the morning from about 10:30, 11, through till 12, and then the afternoon, I think, from 1 o'clock.
Well, what was his mental condition? Sorry. Well, what was his mental? How was he feeling? How was he able to concentrate that morning, say around 9 o'clock? Do you know?
Well, no, I didn't see him at 9 o'clock, but I've no reason to suspect that he would not be able to concentrate at that time.
All right. And, of course, you didn't see him around 3:30 or 4 o'clock, but nonetheless, it is your opinion that he would have the same level of concentration.
It's my opinion that he would be capable of the same level of concentration.
Okay, now you're going to have to help me out here on that one, because you use the word capable. What does that mean? What do you mean by that? Help us out here.
It means that should he have wanted to concentrate, he would have been able to. I mean, there are some things that mean we concentrate to a greater degree. Other things, if the material is not so relevant to us, we may not concentrate to the same degree. But what I'm saying is that I see no reason why he should not be capable of concentrating, should he consider it in his interest to do so.
All right. Now, I think I understand what you're saying. So let me get this straight. If he's fatigued, if he's tired, if he's dozing in and out, you're saying, nonetheless, despite of being in that state, he is capable, he can force himself, will himself to concentrate. Is that what you're saying?
The President, co-prosecutor, you may proceed while Professor Campbell is instructed to hold on, please.
Your Honours, of course I don't want to continually object, but obviously the issue is this expert's testimony is important. And it's important that the questions are clear. In this question, there was two propositions put that made the question confusing. The first proposition was, no, in this state, in the afternoon, when a person is dozing in and out, are you still saying that that they would have the ability to concentrate? What the professor has said, it's clear that he's of the view that during the day, Ieng Sary has a choice whether he decides to stay alert or not stay alert. And so to me, that's the question. Whereas learned counsel is putting forward this factual situation that the accused or a person is dozing in and out. The import of the professor's evidence is that there's some degree of volition of whether or not, in fact, one decides to doze in or out. And so I think that should be the focus of the question. Otherwise, I think it's misleading.
Mr. President, first we started, the objection was that it was confusing. Now it's misleading. Dr. Campbell used the word capable. Capable. Now, the question is rather simple. We have a gentleman who is 87, 88 years old. He has these physical conditions. At times he's on oxygen so he can breathe. He's in pain. So that we all know. And now my question is, if Ieng Sary is dozing off, is it his opinion that it's because of a lack of, this is a choice, that he's exercising a choice? He means to doze off, he doesn't really want to concentrate. Or is it that perhaps because of his physical condition, he's unable to stay alert and therefore unable to concentrate? I hope my question is sufficiently clear. And I see the prosecution is shaking their head, so I think we're not going to get an objection, Doctor.
Well, two things. Firstly, he is physically frail, and that means he will tire more easily than other people. But the length of time of the court sessions are not such that would be too long for him. Secondly, the fact that he dozes off is not an indication that he's not capable of concentrating, not necessarily a reflection on his physical state. We all doze off on occasions.
All right. I see that we're coming up to the hour of the lunch break. I'm about to go into something else, Mr. President. Perhaps we may break at this moment.
The President, International Co-Prosecutor, you may now proceed.
Your Honour, this is not an objection, but in relation to planning this afternoon, I'm aware, I believe, that we have the Professor just here for the day. Defence Counsel have examined for the last hour and 5 minutes, just for planning purposes for the prosecution of the civil parties. I'm just wondering how much extra time the defence will be given for examination, and then obviously the same amount of time should be available for the prosecution and the civil parties. So I'm just wondering, just for planning purposes, particularly with the questions, so that we're as focused and efficient as possible. If we could have some indication before lunch, that would be extremely helpful, Your Honours.
Mr. President, I would have been much further ahead had it not been for some of these objections, which, in my opinion, are gratuitous and unfounded. So that has taken up approximately 20 or 30 minutes of my time. Be that as it may, I think I need another hour with the doctor. Of course, I'm in your hands, so I will do as instructed. I do wish to go into some of the aspects of the testing that the doctor conducted. I don't intend to go into any technical matters, so that won't be too long. I think there's just some very basic questions, and I think one additional hour in light of what is the importance of this is not too much, and I think that should give the prosecution sufficient time with the civil parties in light of your instructions that there be no repetitiveness to ask whatever questions, particularly when, in fact, many of the questions that the prosecution wanted to ask were already asked by the bench. Thank you.
The President, may the prosecution advise the chamber as to how much time they would need to proceed when putting questions to the expert, please.
Your Honours, I think obviously it depends on if what is raised by the defence. If the defence if the defence stopped now, I would suggest that 45 minutes would achieve what we would like to do. 45 minutes or less. As the Defence Counsel, a lot of ground has been covered. But if the defence continues for another hour, they may raise a lot of new issues, of which we would like the opportunity to have more time to address those issues. But as of now, I would suggest that the prosecution would be 45 minutes or less.
The President, what about counsels for the civil parties?
Mr. President, given the state of affairs, I don't believe that we should exceed 15 minutes. Thank you.
The President, with regard to the time allocation and having heard from parties to the proceeding, the Chamber notes that it is appropriate to allow counsel for Ieng Sary to continue putting questions to the expert for another 45 minutes after the break, and the remaining time would be allocated to both the prosecution and the civil party lawyers. And indeed, we will observe sometime also by the end of the day when all parties would then be given an opportunity to have a few final words. The Chamber would like to adjourn for the time being, and the next session will be resumed by 1:30 p.m. Court officer is now instructed to assist Mr. Expert during the adjournment and have him return to the courtroom by 1:30 p.m.